Well, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Jay Cohen. Joining me on the panel today, we've got Judge John Harris from Brevard County and Judge Carrie Ann Wozniak from Orange County. We've got one Zoom, and we're going to go into the courtroom for the rest of the oral arguments this morning. The case we have first is Boulder 3 LLC et al. Versus Buffalo Ridge Property Owners Association et al. Case number 21909. Each side will be entitled up to 20 minutes each for their presentation. We have a default of 5 minutes for rebuttal, but if you'd like something different, all you have to do is just let me know and I'll be glad to accommodate whatever time that you'd like. That said, counsel for appellant, you may proceed.
Morning, Your Honors. I'm Richard Hennings. I'm from Eustis, the law firm of Richard W. Hennings, PA. I represent Boulder 3 and also a corporation called MacWiff. I will refer to that corporation as Mac, and I'll refer to Boulder as Boulder. These are, for purposes of appeal, are consolidated because I had filed a notice of related issues. The facts are, I think, fairly simple in this case. In 2013, Mac purchased by tax deed property, which I'll describe as the north parking lot in the Palm Ridge Plaza. In 2018, Boulder purchased the south parking lot by tax deed. I believe the Boulder tax deed, we paid $182,000 for it. The Mac tax deed, I believe we paid $69,000 for it. This case really involves a statutory interpretation of one particular statute, and actually only about 3 or 4 lines out of that statute. Unfortunately, I'm not able to find any case that interprets the statute the way that we're talking about today. I don't believe counsel has found any specific case directly on point. The statute that we're talking about is Florida Statute 197.573. Tax deeds, of course, are handled differently than, let's say, non-tax deeds such as warranty deeds or trustee deeds, in the sense that tax deeds, once they're issued, the legislature basically says what survives that tax deed and what does not survive the tax deed. Most obvious example is mortgages. If there's a mortgage on the record, then a tax deed will wipe out that mortgage. What we're dealing with today, though, is not a mortgage, but with covenants and restrictions that are in a declaration which was recorded in 2005, which I'll refer to as the Buffalo Ridge Declaration. The Buffalo Ridge Declaration contains various covenants and restrictions. Our position is that the covenants and restrictions of Buffalo Ridge did not survive the tax deed within the meaning of Florida Statute 197.573. And we believe that the statute is unambiguous in what it provides. We also will be talking about the fact that that statute was amended in 2018, which has led to an argument by Buffalo Ridge's counsel that the amended statute applies. But prior to the amendment, 197.573 had this language in the first part of it. When a deed in the chain of title contains restrictions and covenants running with the land, the restrictions and covenants survive the tax deed.
And here, the previous deed, it did reference any restrictions and all that. That was mentioned in the deeds, correct?
The 2000, we're not talking about the tax deed right now. We're talking about Boulder acquired, the original owner of this property being the Palm Ridge Plaza Property Owners Association acquired the property in 2007. MAC also, Palm Ridge Plaza also acquired the property by special warranty deed in 2007. It's just that one was for the north parking lot, one was for the south parking lot. It was because Palm Ridge Plaza, the original owner, did not pay the property taxes that eventually led to the tax deeds. But both of those warranty deeds are virtually identical, with the exception that the grantors are different. The grantees are the same, the Palm Ridge Plaza Property Owners Association. Both deeds do make specific reference to a different declaration, which is a declaration that is still in litigation in this particular case, that being what I call the Palm Ridge Declaration.
Well, the deeds also say subject to covenants, easements, and restrictions of record, if any, correct?
Yes,
okay,
ma'am.
Say that. Okay. So, and that's not enough. And it's your position that that's not enough for the declaration to still apply.
And yes, ma'am, that's correct. And the reason that we do not believe that the declaration still applies under that particular general reservation is because, I would agree that if we were talking about a warranty deed, we were talking about a trustee's deed or one of those non-tax deeds, that the Buffalo Ridge Declaration would be incorporated in the deed, but we're not talking about a non-tax deed. We're talking about a deed that is affected specifically by Florida Statute 197.573. And what that statute said before the amendment was that the covenants and restrictions had to be contained within the deed. It wasn't until 2018 that the statute was amended to say deeds or other recorded instruments. So the covenants and restrictions.
Mr. Hennings, what does the word contained mean in the earlier version of the statute?
I believe the word contained means that the covenants and restrictions have to be within. The word contained means within, have to be contained within the deed itself.
Can't they be contained within by reference?
The statute does not say that. And to that particular point, Your Honor, I think the legislature, I don't see any legislative history on this statute either. The legislature perhaps recognized that the pre-2018 amendment just said it contained within the deed. And so in 2018, they said, well, it also includes other recorded instruments. And our position is that the Buffalo Ridge Declaration is an other recorded instrument. And so if we were talking about tax deeds that were affected by the amendment, then it would include other recorded instruments. But the fact that the pre-2018 statute did not use the term other recorded instruments, I think indicates to me that other recorded instruments like the Buffalo Ridge Declaration would not be included in a tax deed that was not affected by the 2018 amendment. So again, to summarize, I believe that prior to the amendment, the covenants and restrictions had to be contained in the deed itself. And there are no covenants and restrictions contained in the 2007 deeds, which are in the chain of title. There's only a reference to them, and the statute that we have at issue here does not include the pre-2018 statute does not include other recorded instruments such as the Buffalo Ridge Declaration. It doesn't even include the Palm Ridge Declaration, which is not an issue here, but it certainly doesn't include the Buffalo Ridge Declaration, which isn't even mentioned in the 2007 warranty deeds.
If the declaration had been mentioned, if it said Buffalo Ridge Declaration, would that have been enough, or would it have actually had to list every single item that's in the declaration under your position?
Well, under our position and under what we believe is the unambiguous language of the statute, the actual covenants and restrictions would have been included in the deed. And many deeds, not so much with your more modern deeds, but certainly with your less modern deeds, it was quite common to include restrictions and covenants in the deed itself. And in fact, you still see some of those deeds like that. And that may have been the reason that the legislature amended the statute in 2018 to include other recorded instruments, which would, at that point, would include declarations in the chain of title that were simply referenced by the terms subject to covenants and restrictions and easements of record, but not in the pre-2018 amendment. I believe that the covenants and restrictions must be included in the deed. Now, there's no question that the MAC deed is not subject to the 2018 amendment. The MAC deed was issued in 2013, several years before the amendment. There's a question that's been raised by the Buffalo Ridge Council that, well, the Boulder deed is covered by the 2018 amendment. We would disagree with that because if you look at, which is part of the record, if you look at Section 60 of Laws of Florida 2018-118, which talks about the effective date of the statute, Section 60 says that the amendments made by this act to 197.573 first apply to taxes and special assessments levied in 2018. And our position is that even though the Boulder deed was issued about 4 months after July of 2018, that if you look at Section 60 that says that the amendment to 197.573 first applies to taxes levied in 2018, the Boulder deed would not have been issued with respect to 2018 taxes. Now, there's nothing in the record to indicate what taxes were not paid prior to the issuance of the 2018 Boulder deed. But because if you look at the deed on the face of it, it says it was issued pursuant to a tax certificate issued in 2012. But of course, under the statutes, if you're going to bid on property at a tax deed sale, you have to pay not only the amount that was owed on, in this case, the 2012 taxes, but you have to pay all the taxes that accrued subsequent to that. And if you assume that the 2017 taxes were not paid, then that would have been included and the amount that Boulder had to pay when it bid up the tax deed sale. The tax deed was issued in the Boulder tax deed was issued in, I believe it was October of 2018. And of course, the 2018 taxes would not have even been due at that particular time. The only taxes that would have been levied at that point would have been the 2017 taxes. So for that reason, we do not believe that the 2018 amendment to the statute applies to the Boulder tax deed. There was some discussion by the lower court. There was also some discussion in the answer brief about the Marketable Record Title Act. Not really sure why that act was brought into this case, because I think that the survival of the covenants and restrictions is totally determined by 197.573. MARTA is just a general statute that applies to all deeds, and it basically says if you got a deed that's 30 or more years old, you might be able to wipe out covenants and restrictions that are fairly old, fairly ancient. But of course, under 197.573, if the covenants and restrictions do not survive, I mean, they're wiped out immediately. You don't have to rely upon MARTA. So I don't really know why MARTA was brought in, but it was brought in. So that's the reason I'm commenting on it.
Mr. Hennings, you are into your rebuttal time. It's up to you as to how you wish to proceed.
I will end my main argument at this time then, Your Honor.
All right, thank you, sir. All right, Ms. Lim. It'll be easier to hear you if you unmute, but
I'm sorry, I was putting myself on mute to be polite here in the beginning. But may it please the court. My name is Christina Lim. I represent Appley Buffalo Ridge Property Owners Association. Appley is asking this court to affirm the judgments below because the Buffalo Ridge Declaration was properly preserved and survived the tax deed sale under section 197.573 because it was contained within the prior warranty deeds by way of a general reservation, conveying the properties subject to the easements, covenants, and restrictions of record. And that's sufficient under Florida law. Section 197.5.
And do you have any case? What's your best case to support that proposition?
Well, there is very little on the actual tax deed statute, but because the tax deed statute says they survived to the same extent that the covenants would be enforceable against the voluntary grantee of the prior owner, I think what we heard just now was that appellants conceded that if this was just a regular warranty deed, these covenants would be enforceable and the declaration would survive. So to the extent that that's a concession by the appellants, I think that solves the issue here in the sense that these would be enforceable against the prior owners and would be under the tax deed statute as well.
Under your reading of or your interpretation of the statute, would there have been any need then for the legislature to have amended the statute?
The amendment to the statute was a part of an overall statutory amendment that incorporated and created all the rights as well. And the preamble to that statute, the bill specifically says that it's specifying that other recorded instruments are preserved as well. So it doesn't create a new right in that sense. It uses the word specifying, not providing or creating or amending, but specifying. And I think that means that the declaration here would be preserved under the prior versions.
But why would they have needed to do that under your interpretation of the statute?
Well, there could be other recorded documents other than declarations. And if it's simply a clarification, then that makes sense when it's name specifying. But there's also other recorded instruments that are referred to in other portions of the statute that were created by that bill. So I don't think we can just interpret that amendment to mean that declarations were not covered before. Here, it just creates the right that whether the declaration was contained in a deed or not, after the amendment, it is now preserved in a tax deed sale. But the prior versions clearly state that if it was contained within the prior warranty deeds, then it would be preserved as well. And that's the case we have
And
here.
contained, and your interpretation of contained would be referenced?
Correct, contained by the reference that the properties were conveyed subject to covenants, easements, and restrictions of record. And here is undisputed the declaration.
Is there a difference between contained and referenced?
Well, no, I think it's contained within the deed by way of reference to the general restrictions. So there's no need to set out, it's not general practice, and it's not, most warranty deeds don't set out every single restriction and covenant of record. It would be ideal if one could look at every warranty deed in the chain of title and know every single restriction, but that's just not general practice, and that's what the public records are for. So does that answer the court's question?
I got it.
Thank you. So as stated here, the prior warranty deed specifically said that the properties were conveyed subject to covenants, easements, and restrictions of record. And the declaration was recorded in 2005. It was off record in 2007 when those warranty deeds were conveyed. And so it was incorporated by reference in that general reservation. Appellants have not cited to any authority for the proposition that there is a requirement to essentially attach every declaration to a warranty deed in order for it to survive a tax deed sale. And that would also make the holder of the rights under the declaration or any restriction dependent on every seller, every property owner selling a property, attaching the declaration every time they sold the property. And that's just not how the preservation of rights work. Holders of rights preserve their rights by recording them in the public records. And that's why the easements and covenants and restrictions are preserved by general reference in the warranty deed and survive the tax deed sale.
Do you agree with Mr. Henning that MARTA has really no applicability to this case?
Yes, absolutely. There is no applicability here. In fact, the final judgments specifically say that MARTA does not apply. They were only addressed in a footnote. I know there was expended a lot of time briefing them, but MARTA is not applicable here. It only comes into play if the recorded instruments are 30 years or older. And here the declaration was recorded in 2005, and all the other documents were recorded subsequent.
But we love reading about them in briefs when they don't apply. It's a lot of fun.
I can imagine. Let's see. So anyway, so I think the bottom line here is that the covenants and restrictions, the declaration was contained within the deeds by way of the general reservation. That's sufficient under Florida law. It's common practice. And there was another argument made in the briefs, and we didn't hear about it today, but I'm going to address it in rebuttal, though, that specific assessment covenants in the declaration were extinguished as well. However, that argument was waived. It was never raised in the trial court. It was raised in the initial brief for the first time.
Well, it was raised in the original motion for summary judgment, right? But then not the amended motion for summary judgment.
Yes, for one of the appellants it was, but it was abandoned in the amended motion for summary judgment, which was the one that was before the court when these judgments were entered. And it was not addressed otherwise. So that's an issue that was waived, and it would have to be specifically articulated anyway. There's obviously no factual record. And in the reply brief, in rebuttal, there's no citation to any record material that would support that this issue was preserved.
And there's no transcript, right, of the hearing.
Correct.
From the summary judgment proceeding, so we don't know if it was addressed.
Correct.
In the hearing.
There's no transcript. And arguably, I mean, the declaration specifically states that the assessment shall be used exclusively to promote the health, safety, and welfare and recreation of the owners and for repair and maintenance of the common areas. So even under subsection 2, if it had been argued, which it was not, arguably those assessment covenants would survive under the provision that requires that the premises be kept in sanitary and sightly condition or to abate nuisances or undesirable conditions. But again, the appellants specifically moved under subsection 1 in the amended judgments and did not address subsection 2, so it's waived. In regards to MARTA, I don't have anything to add to that. I agree it's not applicable here. And with regards to the to the application of the amended version of the statute to the Boulder tax deed sale, I know appellants pointed to the restriction in time as to when the taxes and assessments were applied, but since the tax deed was issued in 2018, then the assessment would be levied after 2018 anyway, and still would be within the time restriction provided for in the amended version of the statute. But at the end of the day, it really doesn't have to come into play because under any version of the statute, the declaration is contained within the prior warranty deed and therefore survives the tax deed sale under 197.573. And unless the court has anything else, any other questions?
Any other question? All right. Thank you, Ms. Lim.
I'll rest on my brief and ask to affirm. Thank you.
Thank you. Mr. Henning, rebuttal.
Your Honor, not to, I don't want to continue to repeat our argument. I think our argument that I made in my initial argument was clear, and that is that the statute prior to 2018 requires the covenants and restrictions to be contained in the deed. The covenants and restrictions of Buffalo Ridge are not contained in the deed. You have to, in order to get them to apply, you have to rely upon the general reservation subject to restrictions and covenants of record. And while I think Ms. Lehman says, well, that was a concession on my part. No, it isn't. I don't disagree that Buffalo Ridge would be incorporated in a non-tax deed. And the 3 or 4 cases that were cited by Ms. Lehman in her answer brief were cases that dealt with non-tax deeds. We're dealing with a tax deed here, and it's governed by 197.573. There's nothing in the pre-2018 version that says that you bring in restrictions and covenants that are merely referenced in the deed. It says it has to be contained in the deed, and contained, I think, means within the deed. They're not. There would have been no reason to amend the statute in 2018 to add other recorded instruments because I believe just by statutory interpretation, the pre-2018 statute would not have included other recorded instruments. Otherwise, there would have been no reason to amend the statute in 2018. With respect to a point that I didn't really even raise in my opening argument, it was briefed in my brief. The 2018 amendment added a couple of other types of liens that apply to tax deeds. Specifically, the 2018 amendment says that assessment liens by property owners association survive a tax deed. The pre-2018 version of the statute did not have that in it. So that was something also that was added in 2018. And while counsel suggests that, well, I kind of weighed that argument, didn't really make that argument. I mean, our whole focus in the lower court was that the covenants and restrictions and easements of the Buffalo Ridge Declaration do not apply to the tax deeds, do not survive the tax deeds. So we were talking about all the covenants, restrictions, declarations and restrictions in Buffalo Ridge. I just happened to focus in the appeal on one of them, and that was on the assessments, the assessment lien, just to show how the statute had changed from the pre-2018 version to the post-2018 version of the statute. And just the final note, I don't believe the council addressed it. I mean, they say that the Boulder tax deed is subject to the 2018 statute, but again, under section 60, which says it only applies to taxes in 2018, the Boulder tax deed did not involve 2018 taxes. Thank you.
All right, thank you. Thank you, Mr. Hennings. I think that, thank you both for your arguments. I think that the briefs, other than the discussion of Marta, perhaps, did a real good job of setting out the issues, and we'll take the case under advisement. And thank you both for your presentation. We'll be in recess.
Thank you, Your Honor.